Welcome to The Explainer. Today, we're stepping right into the high-stakes world of emergency medical response. This is a world where every single action is weighed and every decision, well, it really matters.
Okay, let's put ourselves right there. You've just arrived on scene. It's a motor vehicle crash. People need help. And your training just kicks in, right? But here's the thing. It's not just about stopping the bleeding or splinting a bone. There's this whole other layer of responsibility that's happening at the exact same time.
Yeah, it's about the law. And from this moment on, every single decision you make, who you treat, how you treat them, even the words you use, it all carries some serious legal and ethical weight. So are you ready? Let's break down the rules that govern these incredibly intense moments.
All right, let's jump into our first section, your duty and standard. These are really the foundations of care.
So let's start with the most basic question. Do you even have to help? If you're just a bystander who happens to see this crash, the law, well, it generally doesn't force you to get involved. But if you're an emergency medical responder, an EMR, and you're dispatched to that call, the answer is a 100% an absolute yes. That's your duty to act. And look at this comparison. It really draws a bright line in the sand, doesn't it? For a bystander, helping is a moral choice. It's admirable, but it's a choice. For you, the on-duty EMR, it's not a choice. It's a legal and professional obligation. And ignoring that duty, well, that can lead to some really serious legal trouble. Okay, so you have to act. We've established that. But the next big question is, how well do you have to act? This is where something called the standard of care comes into play. You can think of it like a legal measuring stick. The law isn't asking you to be a superhero. It's not asking for perfection. It just asks that you provide care like any other reasonable, prudent person with your exact same training would in the same situation. And there it is, in a nutshell. It's that simple and that profound. Use your training. Act like a reasonable person would. The law doesn't expect you to perform miracles. It just expects you to be a competent professional applying what you know to the chaos right in front of you. All right, let's move on. Section 2, the patient's rights. Because this whole thing isn't a one-way street. It's not just about your duty. The patient has some incredibly powerful rights, and it all starts with consent and refusal. So picture this. The person is conscious, they're talking to you, you see a pretty obvious injury, and you know exactly what to do. Can you just jump in and start treating them? It's a question that comes up on almost every call, and the answer is a hard no. You have to ask yourself, who's really in charge here? The law is crystal clear. The patient is.
Right, so you need permission. And that permission, it basically comes in two flavors. First, you've got expressed consent. This is the easy one. A conscious adult looks you in the eye and says, yes, help me. Or maybe they just hold out their arm for a blood pressure cuff. Simple. But what about someone who's unconscious or a small child with no parents around? That's where implied consent becomes so important. The law basically steps in and says, hey, a reasonable person in this situation would want help, so it gives you the green light to act.
Okay, now we get to what is honestly one of the toughest, most frustrating situations for any first responder. You have a patient. They are clearly injured. You explain exactly what could happen if they don't get treatment, and they look at you, they understand, and they still say no. As hard as it is to accept, a competent adult has every legal right to do that.
So what do? Well, you can't just throw your hands up and walk away, and you definitely can't force them. Your job actually shifts. It becomes about communication and, crucially, documentation. You have to talk to them, really try to understand why they're refusing. You explain the consequences, clearly. You make sure they are competent to make this decision, and then you document everything. Get them to sign a refusal form if you can. This is so important because it protects the patient's rights and it protects you from a legal standpoint.
Sometimes the patient's decisions, they were made months or even years before you ever showed up. This is where we get into something called advance directives. Think of them as legally binding instructions from the patient for a time when they can't speak for themselves. And you'll generally run into three main types. First, a living will, which spells out the kind of care a person does or doesn't want. Then there's a durable power of attorney for healthcare, where someone designates another person to make decisions for them. And finally, the one you've probably heard of most, the do not resuscitate order, or DNR. This is a very specific command not to attempt resuscitation if their heart stops. And let me be clear, if you are presented with valid paperwork for any of these on a scene, you are legally and ethically required to follow those instructions. Okay, Section 3. This one is huge. We're talking about keeping secrets safe, because what you see on a call, what you hear, it's not gossip for later. It's not your story to tell. It's protected information, and it's protected by law. Confidential. This one word, it is everything. It's the absolute bedrock of trust between a patient and any medical provider. I mean, think about it. People are calling you on the worst day of their lives. They are at their most vulnerable. They have to be able to trust that what happens next stays private. And this isn't just a nice idea, it's the law. In the US, it's called HIPAA. You've probably heard of it. And it's super strict about who you can share patient information with. The short answer is almost no one. You can share it with the nurses and doctors taking over care at the hospital. That's it. Not your spouse, not your buddies back at the station, and definitely, absolutely not on social media. And this quote just nails a huge modern problem, right? We all have a supercomputer with a camera in our pocket. It's so easy to snap a picture or type out a quick post about a crazy call you just ran. But doing that can be a massive legal violation. A patient's right to privacy covers photos, videos, everything. It's a huge deal.
Okay, so after hearing about all these duties and rules and potential legal hot water, you're probably thinking, man, what about me? What protects me when I'm just trying to do the right thing? And that's a fair question.
Well, thankfully, the law isn't just a minefield. It's also there to help. That's where Good Samaritan laws come in. These laws exist for one simple reason: to encourage people, both regular citizens and trained responders, to help without the fear of being sued if something goes wrong. And here's the bottom line. As long as you act in good faith, meaning you're genuinely trying to help, and you stay within your level of training, these laws have your back. They're like a legal shield. The system really does want to encourage people to help, not scare them away. All right, let's pull all these ideas together and apply them to one last scenario. Put yourself in this situation. You get dispatched to a call, a 9-year-old boy bitten by a dog. He's crying, he's bleeding from his face. The big problem? His parents aren't home and nobody can reach them. So, what do? Let's walk through it. Do you have a duty to act? Yes, absolutely. You were dispatched. Can the patient give consent? No, he's a minor. Can his parents? Nope, they're not there. So what kicks in? Ding, ding, ding! Implied consent. This is a perfect textbook example. The law assumes any reasonable parent would want you to treat their injured child. See how it all comes together? These principles, they're not just stuff you learn for a test. They're the actual framework you will use every single day on every single call.